The elevator doors opened on the 32nd floor, and I already knew something was wrong. It wasn't anything I could point to specifically. The hallway looked the same as it had every morning for 18 years. The same gray carpet with the thin burgundy stripe running down the center. The same framed photos of completed projects along the left wall. The same low hum of the HVAC that you stopped hearing after your first week and only noticed again when it cut out. Everything looked exactly the same, but something in the air was different. The way a room feels different when someone has just left it after a long argument. Even if you didn't hear a word, my keycard didn't work. I stood there for a moment, pressing it against the reader again, watching the light blink red, then a third time. Red. I stepped back and looked at the door like it had said something rude, then pulled out my phone and checked my email. Nothing. Checked my calendar. A 9 a.m. with the Hartwell team, same as always. I pressed the card again. Red. A woman from accounting I'd seen 100 times but never learned the name of came through the door from the inside, and I caught it before it closed. She gave me a look I didn't understand until about 4 hours later. My desk was exactly as I'd left it Friday evening. The mug my daughter had given me 2 Christmases ago. A ceramic thing with "World's Okayest Engineer" printed on it, which she'd thought was funnier than I did, sat next to my monitor. My printed copies of the Phase 3 load analysis were still stacked in the left corner. 18 years of personal accumulation, a framed photo from my son's college graduation, a small cactus my wife had brought in because she read somewhere that they reduce eye strain, a coffee-ringed coaster with the Chicago skyline on it. I sat down and logged in and opened my project folder and got to work, because that's what I did. That's what I'd done every morning since 2007 when I joined Alderton Structural Solutions as a senior software engineer and slowly, over the course of nearly 2 decades, built the analysis platform that had become the backbone of every major bridge and high-rise project the firm had touched in the Midwest. The platform was called STOs. It wasn't a glamorous name. I hadn't named it. But I had built it, line by line, update by update, starting from a clunky proprietary code base that the firm had licensed from a university research lab and ending up with something that the industry had quietly started calling the most accurate structural load analysis tool available to mid-size engineering consultancies in North America. Other firms knew about it. A few had tried to license it. Alderton always said no. At 10:47, my manager's assistant came to my desk and asked if I could come to the 3rd floor conference room. I brought my coffee. My manager, a man named Gerald who had been my direct supervisor for 11 of my 18 years there, was sitting at the table with his hands folded. Next to him was the head of HR, a woman I had spoken to exactly twice in my career. Once when I got a promotion and once when I reported a safety concern about a subcontractor. And next to her was the founder's nephew. The founder's nephew had joined the firm 14 months ago. He was 29 years old and had a business degree from a school I won't name, and had never worked a day in his life in structural engineering. His uncle, the man who had founded Alderton in 1989, who had hired me personally, who used to stop by my desk on Fridays to talk about the Cubs, had suffered a stroke the previous spring and stepped back from day-to-day operations. His nephew had stepped into the vacuum with the confidence that only comes from having never been told no about anything that mattered. His name was Philip. He was wearing a sport coat over a t-shirt, which I mention only because it struck me as the kind of detail that tells you everything. "We're restructuring," Gerald said. He didn't look at me when he said it. Philip slid a piece of paper across the table. I looked at it without picking it up. It was a separation agreement. "We're eliminating the software development division," the HR director said. "Your role no longer exists within the new organizational structure." I looked at Gerald. He was studying the table. "I have a milestone bonus triggering in 72 hours, I said. The milestone bonus was $160,000. I had been building toward it for 3 years. It was tied to the completion and internal deployment of STRUX version 4.0, which had gone live 6 weeks earlier. The payment date had been written into my contract in 2021 when they renegotiated my compensation package to keep me from leaving for a firm in Seattle. I had stayed because of it, because of STRUX. because of everything I'd built here. The restructuring supersedes any pending compensation milestones, Philip said. He said it the way people say things they've been coached to say, rehearsed and empty. I picked up the separation agreement and read it. Then I put it back down on the table. I'll need to speak with my attorney before signing anything, I said. Philip started to say something. I stood up, thanked Gerald, who still wasn't looking at me, and walked out. My wife, Joanna, was home when I got there at noon. She was in the kitchen making lunch, the radio on low, NPR doing something about grain prices. She turned around when she heard the door and read my face the way she'd been reading my face for 26 years. "Sit down," she said. Not a question. I sat at the kitchen table and told her everything while she stood with her arms crossed and listened without interrupting, which is one of the things I have always loved about her. When I finished, she was quiet for a moment. "The bonus," she said. "The 160K. Is that gone? I don't know yet, but you're going to find out." "I'm going to find out," I said. She turned back to the counter and put 2 slices of bread in the toaster. "Call Terrence," she said. Terrence was my attorney. I had used him twice before, once for a real estate matter and once when a subcontractor had tried to claim partial IP on a licensing deal we'd worked on together. He was not a man who got excited easily, which is what I needed. I called him from the back porch while Joanna made lunch. He picked up on the second ring. "Tell me everything," he said. "Start from the beginning." I told him about the separation, about Philip, about the milestone bonus. He was quiet in the way that meant he was thinking, not in the way that meant he wasn't listening. "Do you have a copy of your employment contract?" he said. "The full version, with all amendments?" "Yes." "Get it to me today. I need to read it before we talk strategy." I sent it to him that afternoon. He called me back at 7 in the evening. "Okay," he said. "There are 2 things. First, the bonus. It's contractually obligated. The milestone was hit, it's documented, and the termination, regardless of how they frame it, doesn't erase that liability. We can get your $160,000. And the second thing," I said. There was a pause. "You need to go back and read Section 14, Paragraph C of your original 2006 employment agreement, the one from when you were first hired, not the 2021 amendment, the original." I found it in a filing cabinet in my home office. The original paper copy, slightly yellowed. Section 14 was titled Intellectual Property Ownership and Transfer. I had read it when I signed it, 18 years ago, and then never thought about it again. Paragraph C said this: in the event that the company failed to pay any contractually obligated compensation milestone tied to intellectual property developed by the employee, and in the event that the employee was terminated within 90 days of such a milestone, ownership of the specified intellectual property would transfer to the employee upon formal written demand. STX was named specifically. I sat at my desk for a long time. Then I called Terrence back. "Is this what I think it is?" I said. "If they don't pay the $160,000 within 30 days of the original milestone date," he said, "and you were terminated within 90 days of the milestone, which you were terminated 6 weeks after Go Live, then yes, you own STRUX. The weight of that took a moment to settle. I had built that software across 18 years, version 1 through version 4. I knew every module, every calculation engine, every edge case. I knew where the bodies were buried in the legacy code, and I knew where the elegant solutions lived. I knew it the way you know something you've made with your hands. And now there was a scenario, one that Philip had accidentally created by firing me 3 days too early, in which it could come back to me entirely. What I didn't know yet was that Alderton was 10 days into final due diligence on a $390 million acquisition by Whitmore Capital Infrastructure, a private equity firm out of Denver that had been quietly buying up mid-size engineering consultancies across the country. The deal had been announced internally 2 weeks earlier, though I'd heard only rumors. STRUX was, According to my former colleagues who reached out to me over the following days, the centerpiece of the acquisition's value, Whitmore wasn't buying Alderton's client list or their staff. They were buying the platform. My platform. I found out about the acquisition from a former colleague, a younger engineer named Ben, one of the few people on the development team who had truly understood STOUX at a technical level, who texted me the day after I was let go. Just checking on you. Call me when you can. I called him that evening. They haven't told the acquisition team yet, Ben said. He was speaking quietly the way you speak when you're in an office and not sure who can hear you. But everyone on the tech side knows. Whitmore is in the building 3 days a week. Their due diligence team is basically living in the conference rooms on 8. And STRUX is central to it, I said. It's everything, Ben said. Their whole valuation is built around the platform. Their analysts called it a proprietary moat. I heard it myself. I thanked him and hung up and went to find Joanna. She was reading in the living room. She looked up. There's something else, I said. I told her about the acquisition, about what Section 14C might mean in that context, about the map, which was not small. She closed her book. What does Terrence say? I haven't told him about the acquisition yet. Call him. I called Terrence the next morning. He was quiet for longer than usual. If the IP transfers to you, he said, and they're mid-acquisition, they've got a problem. A $390 million problem, I said. Potentially. But I want to be careful here. This clause, it's never been tested in court. We don't know how a judge would read it. And the other side is going to argue it's unenforceable. They're going to say it was buried, that it was standard boilerplate, that you couldn't have intended to retain IP rights to something that was developed entirely on company time with company resources. And what do we say? We say the clause is clear. It's specific. It names the software. And they breached it by terminating you before paying the milestone. Is that enough? I think it gives us significant leverage, Terrence said. I don't know if it's enough to win at trial, but I don't think it needs to be, because I don't think they want to litigate this. Not with a $390 million deal on the line. The formal demand letter went out on a Tuesday, 3 weeks after I was let go. Terrence had drafted it, and it was precise and measured and 13 pages long, and it said, in essence, you owe my client $160,000 in contractually obligated compensation. You failed to pay it. Under the terms of the original 2006 employment agreement, specifically Section 14, Paragraph C, ownership of STRUX has therefore transferred to my client. We are formally notifying you of this transfer and demanding recognition of same. I don't know exactly what happened inside Alderton when that letter arrived. I can only piece it together from what Ben told me later, and from what became obvious in the days that followed. What I know is that within 48 hours of the letter going out, Philip called Terrence directly. Terrence told me about it afterward, professionally, without editorializing, though I could hear something in his voice. He called me aggressive, Terrence said. What did you say? I told him that the letter was a formal legal notice, not an act of aggression, and that any response should come through his legal counsel. Philip's legal counsel called the next morning. They said the clause was unenforceable. They said the separation had been executed properly under the terms of the 2021 amendment. They said my client's claims were without merit. Terrence responded calmly. He explained the specificity of the clause. He explained that the 2021 amendment did not supersede Section 14 of the original agreement because Section 14 had been explicitly carved out from the renegotiation. I had insisted on that in 2021 precisely because STRUX was approaching a critical development phase, and I wanted clarity on IP. Their own attorneys had signed off on that carve-out. There was a silence on the other end of the call. Then, we'll be in touch. I want to be honest about those weeks, because I think when people tell stories like this, they tend to clean them up. The truth is that it was not a triumphant period. I was 53 years old and I didn't have another job. My daughter was getting married in the spring and her mother and I had promised to contribute. My son had just started his second year of graduate school. I had savings. 18 years of careful living, but savings are not a salary, and I was aware of the clock ticking in a way I hadn't been since my early 30s. Joanna was steady, the way she always is. She's a school librarian. She had her own income, her own insurance, her own professional life. We had built things together in a way that meant one of us losing a job didn't mean catastrophe. But I won't pretend I slept well. I won't pretend there weren't nights where I lay in the dark running the math over and over, wondering if I was right, wondering if Terrence was right, wondering if some judge somewhere would look at Section 14C and shrug. 3 weeks after the demand letter, Whitmore Capital's legal team entered the conversation. They hadn't been at the table before that. It had been Alderton's attorneys, Phillips' attorneys, the corporate restructuring team, but now a managing partner from Whitmore was on a call with Terrence, and the tone was different. "They're informed," Terrence told me afterward. "Informed how?" I said. "They've done their own read of the clause. They have their own outside counsel looking at it, and they're asking whether there's a resolution that keeps the deal on track." "What does that mean?" "It means they want to know if there's a number." I thought about that for a long time. The math was not complicated on the surface. If STRUX belonged to me, and the acquisition valued STRUX at the core of a $390 million deal, then my leverage was not $160,000. My leverage was considerably larger. Terrence laid it out carefully. He wasn't pushing me in either direction. He walked through the options. Option 1, litigate. Sue for recognition of the IP transfer. It would take years. It might fail. Even if we won, STRUX in my hands without Alderton's client infrastructure and staff would be worth significantly less than it was inside the company. Option 2, negotiate a settlement with Alderton directly. Get the $160,000 I was owed, plus additional compensation, in exchange for releasing any claim to the IP. Clean, fast, but limited. Option 3, negotiate directly with Whitmore. They were the ones with real money on the table. They were the ones who needed clarity on ownership to close a $390 million deal. They might be willing to pay for that clarity. I asked Terrence what he thought. "I think Whitmore is your best pressure point," he said. "But I want you to understand what you're doing if you go that route. You're not just negotiating your bonus. You're negotiating as the person who holds the key to their entire deal. That's a different kind of conversation. It carries different risks." "What risks?" "If you push too hard and they decide to walk away from the acquisition entirely, Alderton may blame you for the collapse of the deal. There could be litigation on the other side. And if you're seen as having weaponized an IP clause in bad faith—" "It's not bad faith," I said. "The clause is legitimate. They breached it." "I know that," Terrence said. "I'm just making sure you know what you're walking into." I talked to Joanna that night. For a long time. We sat at the kitchen table after dinner, and she listened to everything, and then she said, "What do you want out of this? Not the money. What do you actually want?" I thought about it. "I want them to know they were wrong," I said. "I want Philip to understand what he threw away when he walked into that conference room in his sport coat and slid that paper across the table. And I want what I'm owed. The $160,000. "What I'm owed," I said again. She nodded slowly. "Then that's what you ask for," she said. Clearly, without games, what you're owed and what it cost them to have been wrong. The negotiation with Whitmore took 9 days. I won't go through all of it in detail because most of it was attorneys talking to attorneys in conference rooms I wasn't in. But here's what I can tell you. Whitmore's outside counsel made it clear in the first session that they viewed the IP clause as having a colorable basis. Their word, meaning they weren't willing to bet $390 million that it was unenforceable. The risk was real enough that they needed it resolved. Alderton's position shifted after that. Philip's attorney stopped saying the clause was entirely without merit and started talking about what a reasonable resolution might look like. The final agreement, which I signed on a Thursday afternoon in Terrence's office in the Loop, included 3 things: the $160,000 milestone bonus, paid in full, which was what I had been owed from the beginning, An additional settlement payment that I agreed to keep confidential in terms of the exact amount, but which I will say was sufficient to make Joanna cry quietly in the car on the way home, in the good way, and a formal acknowledgement, written into the settlement, that my termination had been improperly executed under the terms of my employment agreement. Philip was not mentioned by name. The acknowledgement was clinical and corporate and bloodless, but it was there. I did not get $12 million. I want to be clear about that, because I've told this story to a few people and they sometimes assume that the IP leverage translated into some massive windfall. It didn't. The number Whitmore was willing to pay for resolution, which was also the number Alderton's liability actually supported under the clause, was not retirement money. It was meaningful. It was real. But it was not the kind of number that changes every calculation you've ever made about your life. What changed was something else. The week after the settlement, Ben called me. He left Alderton. He wasn't the only one. The acquisition had created a lot of uncertainty, and a handful of the senior technical staff had decided not to wait around to see how the new ownership changed things. He asked if I thought about what I was going to do next. I told him I had some ideas. What I had was the acknowledgement that I'd built something worth $390 million to a private equity firm, and the knowledge of exactly how it worked and where its limits were, and 18 years of relationships with the structural engineers and project managers who used it every day. What I had was the understanding that STRUX was powerful and that STRUX had a ceiling, things only I fully understood. Ben and I started talking, seriously, about what it would look like to build something new, not to compete with STRUX directly, but to address the problems that STRUX couldn't solve, the edge cases I'd known about for years and never had the organizational support to fix. Real-time seismic load modeling, dynamic wind interaction for hybrid structures, the stuff that everyone in the industry knew was coming and nobody had built yet. We didn't have capital. We had conversations. We had a shared understanding of a gap in the market that we were uniquely positioned to fill. 6 months after I signed that settlement, Ben and I incorporated. A woman from my network, a structural engineer named Patricia, who I'd worked with on a major overpass project in 2019, joined us as a technical lead. We found a small office in Evanston, close enough to the city that we could get to clients easily, far enough that the rent wasn't punishing. I'm not gonna tell you it's been smooth. Starting something at 53 is not the same as starting something at 30. The risk feels more real because you understand it better. But I will tell you that I have not thought once about those 72 hours. The key card that didn't work, Gerald's eyes fixed on the table. Philip's sport code, with anything other than a kind of clarity. He thought he was getting rid of a cost center. He thought he was streamlining. He thought he'd found a gap in the calendar, a Monday termination, a Thursday milestone that would save the company $160,000 and tidy up the org chart before the acquisition closed. What he'd actually done was remind me that the thing I'd built had value, real, large, documented value, real, large, documented value, and that I was the one who understood it best. Joanna asked me, a few months in, if I missed Alderton. I thought about it honestly. I miss Gerald, I said. I miss Ben, but he's here. I miss some of the projects. The overpass work, the stadium retrofit, but not the place itself. No, I said. Not the place itself? She nodded, satisfied with that answer. Outside, the February wind was moving through the bare trees in the backyard, the kind of sharp Chicago cold that clears everything out and leaves the sky absurdly blue. My daughter's wedding was 2 months away. My son had called that morning about his thesis. The new code base was sitting open on my laptop in the other room, a problem I'd been turning over for 3 days starting to look like it had a solution. I poured a second cup of coffee and went back to work. I keep coming back to the moment Gerald wouldn't look at me. Not Philip, not the HR director reading her prepared lines. Gerald. 11 years of working together. 11 years of him stopping by my desk to argue about the Cubs and approve my project roadmaps, sitting with his hands folded and his eyes fixed on the table like the surface of it held the answer to something. I think about that more than I think about any other part of what happened, because Gerald knew. He knew the clause existed, or at least suspected it. He knew the timing was wrong. And he sat there anyway. What Philip didn't understand, what people like Philip rarely understand, is that actions have weight that accumulates over time. He walked into that room thinking he was making a clean, efficient business decision. Eliminate a cost center, tidy the org chart, save $160,000 before a $390 million deal closed. Clean math. Except he hadn't done all the math. He'd read the 2021 amendment and stopped there. He didn't go back to 2006. He didn't think it mattered. That's not a failure of resources. It's a failure of integrity. Not in the dramatic sense, but in the structural sense. When you cut corners on how you treat people, you tend to cut corners on the details too. Philip's carelessness with me, and his carelessness with Section 14C of my original contract, came from the same place. A fundamental belief that the people beneath him weren't worth his full attention. What I've learned, and I mean really learned, not just understood in the abstract, is that the choices you make about how to work and how to treat the people around you are not separate from the outcomes you eventually face. They're the same thing, just separated by time. I spent 18 years building something carefully, not because I was calculating a future leverage point, because that's how I work. Every module in STRUX was built the way it was because I cared whether it was right, not just whether it ran. That care, that insistence on doing the thing properly even when no one was checking, is what made it worth $390 million to a private equity firm, and it's what made Section 14C enforceable. The clause meant something because the work meant something. There's a kind of intelligence that only comes from staying with hard problems long enough to understand them from the inside. Terrence understood it about contract law. Ben understood it about contract law. Ben understood it about code architecture. Joanna has always understood it about people. That's what I was drawing on when everything fell apart. Not luck, not connections, but 18 years of paying close enough attention that I knew exactly what I had and exactly what it was worth. And then there's the part nobody talks about, the weeks when I didn't know how it would end. The nights of running math that didn't add up. The fear that I'd misread the clause, or that a judge would shrug at it, or that I'd push too hard and Whitmore would walk and I'd end up with nothing but a settlement letter and a cactus in a box. Getting through that, not collapsing under the weight of it, not taking the first settlement offer out of pure anxiety. That required something quieter than confidence. It required the ability to stay in an uncomfortable place long enough for clarity to arrive. Ben and I are building something now. It's early. Some weeks are harder than others. But I know what I'm doing and why I'm doing it, and I know the people I'm doing it with. That's more than I had at 25. Philip is still at Alderton, as far as I know. The acquisition closed. He got what he wanted. I got what I built.